Child custody is one of the more emotionally charged aspects of Texas family law. So let's break it down together. My name is Bobby Dale Barina, and I am the founder and chief legal strategist at the Barina Law Group. And today, let's talk about Texas family law and Texas child custody law in an attempt to make it more manageable and by understanding it to reduce any anxiety that may be in play. Now, in Texas, we really have, outside of CPS court, we really have three different types of conservatorship. The first is joint managed conservatorship, and that's where you're really equal in almost every respect, except one parent generally has the right to establish domicile. And with that right to establish domicile, they will receive periodic payments for the benefit of the child or children. That'll be child support payments and medical support payments. Sometimes you'll see orders that put educational decisions in that same type of one party, one parent has the right to make all the decisions. But joint managing conservatorship really says the two of you can always work together to put the children first and make the best decisions for them. Outside of that, we have one above that, and that's sole managing conservatorship. And really what that's saying is one parent makes every decision and has every right, except for visitation, which is the last one, possessory conservatorship. And they have the ability to have visitation with the children. That's usually after some domestic abuse, some child abuse, something, drug abuse that says I can't make any decisions. And usually my visitation has to be supervised by either the other parent or a third party. You can generally work out of that through a stair-step system, but that's really what it's saying is that you are at the bottom here, and to get anything, you have to have a further order of the court. Now, how do we come up with these different designations of what your legal relationship is with the children, joint, sole, or possessory? Well, that's through the best interest factor. And the best interest factor is really putting the child and the children's needs first and foremost in every decision. And that's just a myriad of examples of who can provide for the children financially, emotionally, provide a home for them, food, clothing, shelter, always be there. And at the end of the day, make sure those child or children have the best possible lives possible and be the best kind of adults they are. Now, the factors that influence the custody decision, again, those are the best interest factors. But you're also looking at who is working, who is spending time with the children, who is doing homework, who is taking the children to the doctor, arranging for child-appropriate play dates, age-appropriate play dates, all these things. The next thing we really look at is what is the visitation schedule for the parent that doesn't have the right to establish domicile. And in Texas, we have different kinds. We have under 50 miles, and then by default, 50 to 100 and over 100 miles. And we really set them out in a written order. And you can have any type of visitation if the two parents agree, but if not, you have this fallback called the standard possession order. And the standard possession order is generally first, third, and fifth weekend. When I say that, I'm really looking at families under 100 miles from doorstep to doorstep. Now, those can start at when school gets out. It can start at 6 on a Friday. It can end at 6 on a Sunday. It can have the children return to school on Monday morning. These are all things you'd want to look at to see if they're possible for you. If your work schedule, your home schedule allows for increased times by making the beginning and the ending times a little bit more expansive. Speak to an attorney about that if you need to, but getting an understanding that that's a possibility really helps. Now, how do you modify an order? There has to be a substantial and material change. Those are weird words, but a substantial material change to the existing order or the existing relationship that makes a modification necessary. And when you look at that, parties get married. After they divorce, the children get older, even though that's not really the best example. People move apart from each other. These are material essential changes that sometimes need the order to be modified. Now, how do you enforce an order? Well, the enforcement is you have the written order. You say we're going to go by that. and one party fails to live up to that written order on the visitation schedule, perhaps they deny you visitation, you can't get there, you go to the home, you do everything you're supposed to, and they just turn you away saying you're not going to visit your child. Well, then you can go back to court. You have to serve them personally. You go back to court and you make these allegations in written documents, and then you prove them up in court. Relocation in custody is always a big issue when one party moves away. Most orders will address it by saying either there's a geographic restriction to the county where they are now and adjacent counties, or it will say without regard. You can establish where the children live without regard to a geographical restriction. If you do have a geographic restriction, you would need to look at the best interest factors to see if moving's appropriate, how this is going to benefit that child or children in what ways, and how that can't be accomplished locally. Now, legal and physical custody, we come up with the right to established domicile, the right to visitation. Now, I did mention earlier standard visitation. Now, standard visitation guidelines, again, first, third, and fifth weekend of the month. If you're over 100 miles, there's a different way of approaching it, but these are called parenting plans. And a lot of times you can modify them, you can tinker with them to address your specific situation, your family situation. And that is if shift work comes into play and things like that. Now, if you want to discuss and have tailored advice to your individual family, because all families are unique and different, then reach out to us at the Barina Law Group at 254-699-3755. Thank you.